Good afternoon. It's about 1:30, so I think we should probably get started on this webinar. My name is Greg Denny. I've been with Bugby & Conkle for quite a few years. I won't say how many. A lot of my practice has been involved with safety and safety issues, and as a result, I have defended employers in both VSSR claims and also employer intentional tort actions. And so in preparing the webinar, I thought we would explore both of these types of causes of action and see if in fact there's any relationship between the two. So in order to do that, I think we need to go through the basics of a VSSR, which is a violation of a specific safety requirement, and also the basics of the statute in Ohio that provides for an employer intentional tort action. So we'll compare the two, and at the end of the presentation, I will take any questions that anyone might have, and we'll see if in fact there is any connection between these two animals. So let's talk about VSSRs. Violations of specific safety requirements fall under the Industrial Commission's auspices, as you probably all know. The VSSR, believe it or not, was created when Ohio amended its constitution and created the workers' compensation system back in, I believe, 1911. And up on the screen, I put Article 2, Section 35, the relevant portion of that constitutional provision, which creates the claim of a violation of a specific safety requirement here in Ohio. Although there is a statutory provision, it doesn't deal with this specifically. The Constitution merely says that if there's any injury or disease that is caused by the failure of the employer to comply with any specific requirement for the safety of employees, then the Commission has the authority to assess a dollar figure against that employer, the amount of which is between 15 and 50% of the maximum rate of compensation established by law. That is the constitutional provision, and that is what we've been operating under for the past 110 years or so. So in response to that constitutional provision, a number of codes of specific safety requirements were adopted by the Commission and by the Division of Safety and Hygiene. They are up on the screen, and as you can see, they pertain to various industries. The catch-all code is 5, dealing with workshops and factories. But if you're running a steel mill, you need to be aware of code 9, because that code would have specific safety requirements dealing with the type of machinery, the type of equipment involved in manufacturing steel. Same thing with regard to construction. Construction has its own set of safety requirements, and the specific industries requirements trump any possible requirements in the general Chapter 5 because they do and because the courts say they do. So you might have a couple requirements that apply to a particular situation, but the specific will always control over the general. And if there is not a specific requirement in the construction code or in the steel mill code, an employer still may be liable for a violation under workshops and factories, the general code, if in fact it applies to the particular situation, and if in fact there is not a provision in the specific code for steel mills that would apply. So we have a number of codes, and all codes have a number of chapters containing specific safety requirements. There is a grandfather clause in the law that says that if in fact you have a installation or a construction that's built and it complied with the specific safety requirements at the time it was installed or constructed. So you take a conveyor line or perhaps a large piece of equipment in a manufacturing facility. If that piece of equipment or that conveyor line complied with the requirements on the date that it was installed or constructed, and an injury occurs 25 or 30 years later, and the injury results from a violation of a specific safety requirement that had been enacted after the installation or construction, the employer is not liable because of this grandfather clause, as long as the equipment complied with the code in effect at the time of the construction or installation. The employer has complied with the law, and there will not be an additional award for a VSSR in that situation. Note, it doesn't apply to any mobile equipment or any personal protective equipment, only to installations or constructions. So, as I indicated, there's not much statutory law dealing with VSSRs. All of the law has come about through case law over the decades. And if you read enough cases and you handle enough of these claims, there's some principles that bubble up that you should know about. The first one is, obviously, the activity and the injury has to fall within the parameters of a particular code, as we talked about before. It cannot fall outside of a code. There are cases where there is an injury. I believe there was a tree trimmer in a cemetery, and the chainsaw did not have a guard on it, and a VSSR was filed against the employer, and a citation under the workshops and factories provision was argued to have been violated, and the employer won that VSSR because the injury did not occur in a workshop or factory. It occurred in a wide open cemetery without any fence or enclosure, and case law in Ohio indicates that for the workshop or factory code to apply, the workspace, the work area must be enclosed. So, i.e., the principle is that the activity must be within the coverage of the particular code cited. Second principle that goes through this area is that the requirement must be specific. And what does that mean? That means that the safety requirement must clearly inform an employer of how to comply with the requirement. It cannot leave the employer guessing or choosing between alternative ways of complying with the safety requirement. It must be clear and specific as to exactly what the employer must do to comply. If it's not a specific requirement to that degree, an employer cannot be held liable. The next item, which again might be understandable, I think it is, the employer has to have the ability to alter or correct the particular piece of equipment or machine. That's why when you have a temporary employment agency, temporary employment agency might be the employer for purposes of the underlying workers' compensation claim, but the temporary agency will not be held liable for a VSSR that comes out of that claim, for the reason that the temporary agency has no authority, no power, no control over the equipment or the machinery on which the employee was injured at the customer's place of business. In that situation, it would be the customer employer who may be liable for a VSSR, even though the underlying claim is against the temporary agency. So again, the authority to alter or correct has to be there. Otherwise, how could an employer ever comply with the requirement if it had no authority to alter or correct the machine? Proximate cause. An employer can be in violation of a specific safety requirement, but if the facts show that that violation was not the proximate cause of the injury, then there's no basis for an additional award of compensation. Many times we see this where perhaps there wasn't a particular PPE provided, or perhaps a guard was not installed on a nip point, but the individual's injury really had nothing to do with that area of the machine or that violation. And if there is no proximate cause, there is no VSSR liability under Ohio law. The next defense or general legal principle in this area is what we call the employee's unilateral negligence. As long as the employer has complied with the specific safety requirement, an employee's negligence in either defeating that compliance or jimmying something to bypass a guard or taking a guard off for whatever reason, in that situation, the employee will lose the claim because the employer has done everything it could do to comply, and it would be solely the employee's negligence and the employee's sole negligence that caused the injury. And in that situation, there can be no VSSR liability. Okay, what if you put a safety device or a safety guard on a piece of equipment and it fails? You know, say you have a pullback mechanism on some type of a punch press in a manufacturing facility, and it complies with the requirements under the appropriate and applicable safety code dealing with mechanical punch presses. But let's assume that it fails. Not the machine, but the actual guard. The pullback guard did not do its job and did not take the operator's hands away from the danger zone as it was designed to do. If that occurs, and it's the first time that the safety device fails, there is no VSSR liability. The courts are clear on that. However, you need to fix it, because if it happens a second time, and I mean if it happens, even if there was no injury involved with the first failure, if the employer knows that the safety device has failed or is in need of repair and does nothing, and an employee is then injured because of that defect, the employer will in fact be liable for the VSSR, even though the cause of the injury was the failure of an appropriate safety device. And the purpose, obviously, and the reason that the liability would exist is because of the employer's knowledge of the defective safety device and the employer's failure to do anything to remedy the situation. Even though a VSSR award is deemed additional compensation for the employee, the law and the case law make it pretty clear that it's in the nature of a penalty as to the employer. It's really punishment and a penalty against an employer for failing to abide by the applicable safety requirements. And because it's in the nature of a penalty, the law makes it clear that all questions regarding the interpretation of a particular safety requirement, all questions regarding the application of a particular safety requirement to a particular claim, to a particular machine, all those questions must be resolved by the Industrial Commission in the employer's favor. So these types of claims are somewhat difficult for a claimant to succeed on, because any questions as to interpretation, as to whether the code applies, as to whether the code applies to this particular machine, all of those questions that exist in a hearing must be resolved in the employer's favor. It's almost the exact opposite of how things are interpreted and applied in the underlying claim, where the claimant is given the benefit of the doubt. In a VSSR hearing, and under Ohio law, the employer is given the benefit of the doubt where there are questions as to interpretation and application. The award, as the Constitution stated, can be anywhere between 15 and 50% of the maximum weekly compensation. That is not the weekly compensation the employee receives. It's the maximum rate here in Ohio. So if you have a 2019 injury, I believe the maximum TT rate for 19 is $950 a week. So it would be off of that rate that the VSSR is applied. So if there's a, let's say a 30% award, Commission finds a violation and awards a 30% award, then every week of compensation that was paid in the claim and to be paid in the claim would be multiplied by 30% times $950, even though the claimant may have only received $550 based on their AWW. So that is the penal nature of the award. And oftentimes, especially with state fund employers, smaller employers, these types of claims, VSSR claims, can be financially devastating, especially if you have a PTD situation or perhaps a death claim. Oftentimes the VSSR award is significantly higher than the compensation that's being paid in the claim. And the award stays with the claim for the life So even if you're a state fund employer, your experience period is 5 years. Not so with the VSSR. The employer pays this directly, state fund or self-insured, and it's paid over the life of the claim, be it 5 years, 10 years, or 40 years. And the Commission has all kinds of discretion as far as determining what percentage to award. They look at how serious the injury is, the employer's track record on safety, the seriousness of the violation in the particular claim. I mentioned early on there is a statutory provision for safety violations. It's contained in 4121.47. It is a little different than what we've been talking about. The awards that we've been talking about to the claimant, that is all grounded and based on the constitutional language. This enforcement and civil penalty statute came into being, I don't know, 15 years ago perhaps, maybe 20 years now, but it focuses on the violation, and it empowers the Commission to investigate and to enforce specific safety requirements. And how it does that is the Industrial Commission can order an employer to correct a violation that it finds, and failure to correct the violation actually constitutes a violation. And so this statute really permits for a fine to be levied against an employer if in fact there are 2 or more safety violations within a 24-month period. And the fine is rather hefty. Maximum amount is $50,000 for each violation. So if you have a violation and the commission determines that, well, you didn't put those guards on that press, so you violated a specific safety requirement, but in this claim that we're hearing, the claimant was injured because the claimant tripped over the base of the press, i.e. it had nothing to do with the violation. Even if there's no proximate cause between the violation and the injury, this statutory provision gives the commission the authority to find the violation, to order that it be corrected, and if the employer fails to correct it, then the employer would be subject to a fine of the amount that I've already indicated. And remember, all of this happens even if it cannot be shown that an injury resulted from the violation. So again, in my experience, the commission does not really pursue these types of fines and orders to correct, but they can. And just because I have not seen it, I think I've seen it once, maybe twice, doesn't mean that there are other employers who have experienced it. And then the procedures, we can go through this really quickly. You got 2 years to file it. The application can be amended to include and change the requirements that are being cited. You can do that after the 2-year period. The Bureau then, Department of Safety, Hygiene, they investigate these claims, no expense to the claimant, and then a pre-hearing conference is scheduled. And at the pre-hearing conference, procedural matters are discussed. A final merit hearing is scheduled. Commission doesn't like to continue those merit hearings because they allocate 2 or 3 hours for each hearing. And so once you get your merit hearing date, pretty much that's a go on your calendar, and you won't be able to cancel or continue that hearing unless the matter is settled and settlement papers are filed before the merit hearing. Each party has the right to request a record hearing, which merely means that a court reporter will transcribe the testimony and the arguments at the hearing. I always request a record hearing on behalf of the employer for the simple reason that without it, you're pretty much stuck with what's been filed with the investigator, the investigation report, and any other documents that the parties want to file with the commission before the hearing. So you're not allowed to submit new or additional evidence at the hearing unless you request a record hearing. And that record hearing has to be requested before the pre-hearing conference. If you have an intentional tort case pending that arose out of the same accident, then if the parties agree, the commission will hold the VSSR in abeyance pending final resolution of the intentional tort action. Most of the time, if there's an intentional tort case pending in a trial court and a VSSR claim filed in the commission, my experience has been that most attorneys will agree to hold the VSSR in abeyance pending resolution of the intentional tort action. Once it does go to hearing, you get a decision from a staff hearing officer, and each party has 30 days, I believe, to request a rehearing. They're difficult to get, the rehearings, because they must be based on an obvious mistake of fact or a clear mistake of law. So pretty much the hearing of the decision of the SHO is going to be the decision of the commission with a very few exceptions. And then the only way you can challenge a decision of the commission in a VSSR is to file a petition requesting a writ of mandamus, usually filed with the Franklin County Court of Appeals. since the commission sits in Columbus. Obviously, anything can be settled, including VSSR applications. If you settle a VSSR, then you do not have a violation for purposes of that statutory fine we talked about. And my experience has been that more and more VSSRs are being filed by claimants' attorneys, and they're being filed for the sole purpose of trying to settle them. Many for nominal sums where there is no real basis for a finding of a violation, and yet that's the world we're living in right now. And employers are willing to pay a nominal sum to get out from under some of these VSSRs that are being filed. Years ago, you didn't see many VSSRs. I mean, the ones you saw were based on serious injuries, usually some type of a loss of an appendage in a machine, and the exposure was quite large, and most of them, at least the ones I was involved in, went to hearing. Now we're getting VSSRs and claims with very little exposure, not much compensation, relatively minor injuries, and as I indicated, I think there are certain firms in Ohio that are filing VSSR applications similar to a C-92, a way to generate some income. And so that's pretty much VSSRs. The thing to take away from it is the employer's intent really has nothing to do with the VSSR. If you have a specific safety requirement and the employer does not comply with it, then and it causes an injury, then that's pretty much the end of the story. What the employer knew, or the employer wasn't aware of the safety requirement, or the employer didn't understand it, none of that makes any difference. The fact is, here's the requirement. Did you comply or did you not comply? If you didn't comply, did an employee get injured as a direct result of your noncompliance? If that's the case, then the commission will have a basis to find a VSSR. Contrast that with an employer intentional tort. These are actions that are filed in common pleas courts throughout Ohio. Years ago, we had what we call the common law intentional tort substantial certainty test, and we'll get into that in a second. But I believe this statute went into effect in 2005, 2745-01, A and B. And it was Ohio's attempt to drastically restrict intentional tort liability for employers. And what this section indicates is that an employer is not going to be liable in damages for an intentional tort to an employee unless the employer commits an act with the intent to injure the employee, or commits an act with the belief that the injury was substantially certain to occur. And then what the statute does in Section B, it defines substantial certainty as that an employer acts with deliberate intent to cause an employee to suffer an injury, a disease, a condition, or death. So even though it's in the terms of substantially certain, the statutory language makes it clear that substantially certain means deliberate intent to injure. So if you read A and B together, the bottom line is that the plaintiff must establish and prove by a preponderance of the evidence that the employer acted with an intent to injure the particular plaintiff. And without that intent, there can be no cause of action, no judgment against this employer for an intentional tort. So if you look at the basis of an intentional tort by its very language, by its very term, it differs from a VSSR because intent has nothing to do with VSSR liability. It has everything to do with intentional tort liability. So in 2010, there was a lot of litigation over the statutory provision, as you can expect, because before this statute went into effect, we were defending a lot of intentional tort cases in Ohio because the standard was rather broad, the substantial certainty standard. And an employee could recover from an employer for an intentional tort under common law if the employee could show three things. Number one, that the employer knew there was a dangerous situation, a dangerous machine, a dangerous whatever in the plant or in the workplace. That the employer knew that if an employee was exposed to this danger, injury was substantially certain to occur. And with that knowledge of the danger and knowledge that an injury was substantially certain to occur, the employer required an employee to be exposed to the danger. As you can see, those three requirements are kind of discretionary, and you can make them apply to a lot of situations, whether it's a depression or a hole in the floor, or perhaps oil leaking out of a machine that had been leaking for quite a while, and it was clear that if somebody walked in the pool of oil, they'd fall and hurt themselves. And so we were receiving a lot of complaints for intentional torts. And it was that situation that the legislature adopted 2745 to remedy and to restrict that type of liability for an employer, the intentional tort liability, to only situations where it can be proven that the employer intended to injure the particular employee. Kaminsky finally in 2010 held that it was constitutional, and obviously, as I just talked about, it significantly restricted the common law intentional tort cause of action. The next couple slides, I'm just giving you a few examples of cases that were decided under the new law and how the court came out. And it just sort of illustrates what I've been talking about, that you need intent to injure. In this Klaus case, the company had a lockout tagout policy. They never told their employees about it, and no one followed it, and they didn't enforce it at all. And they let each employee figure out how to do it themselves. Is basically what they did, and obviously somebody got caught in a running machine. I mean, something like that was just bound to happen with that type of a situation. But even under those facts, the court held that's not a basis for an intentional tort. Might be negligence, it might be gross negligence, but it doesn't arise to the standard of an intent to injure the employee. Hubble case comes out of the same district, the 3rd district, which is in Northwest Ohio here. This one is just as bad as the one we just talked about, but this employer was stacking these plastic bales, very large plastic bales. They were very unstable. They had fallen before. OSHA had been at the plant. OSHA had cited this employer for the unsafe stacking of these large volumes of plastic. There were prior incidents of the plastic falling over. I think there was also a prior incident of someone actually being hurt in one of the prior incidents. And despite that, despite the OSHA citations, despite the prior incidents, when somebody was they required people to clean the floor and sweep the floor around these bales. Needless to say, one of the bales toppled over and injured an employee. That employee filed an intentional tort case, and the court threw it out saying there's no intent to injure here. Dangerous work situation. The employer was negligent. The employer was reckless. The employer, it almost amounted to gross negligence, gross recklessness. But even at that level, the court said there's no intentional tort liability because there's no intent on the part of the employer to injure the employee. McCarthy Sterling, another one. Employer had people working on top of rail cars 15 feet in the air, no PPE, no fall protection. They didn't train them, they didn't supervise them. They just put the employees up on these train cars and said, do this, do this, do that. Somebody falls off a car, files an intentional tort case. Same result as in the prior two cases. Because there's no proof of intent to injure, employer is not liable for an employer intentional tort. The claimant's only remedy would be the workers' compensation claim for the injury suffered and possibly a VSSR. And in a situation like the one in McCarthy, I would be pretty sure that there would be a VSSR violation here. Hudak, another gross example of negligence on behalf of an employer who could care less about safety. This employer assigned employees to work in a dark aisleway in the plant. Side loaders are moving in and out of that aisleway. There's no reflective vests. There's no cones. There's no caution tape. There's no gate. There is nothing to prevent or at least lessen the probability that one of these side loaders is going to run into one of these employees working in the aisle. And what did the employer do? Just told the employee to tell the side load operators that you're working in the aisleway. That was the safety procedure. Another gross negligence situation, but again, no intentional tort liability, despite the fact that I'm sure there would be VSSR liability in this case. Again, intent is necessary for employer liability on an intentional tort case. Intent is not necessary for a VSSR. Black and white. Is there a safety requirement? Has the employer complied with it? And if not, did the non-compliance with the VSSR proximately cause the claimant's injury? That's just what I've just been saying. Must show deliberate intent to injure the employee. Now, there's one other paragraph in 2745.01c that you need to be aware of. And it's up on the screen now. The deliberate removal by an employer of an equipment safety guard or the deliberate misrepresentation of a toxic or hazardous substance creates a rebuttable presumption that the removal or misrepresentation was committed with the intent to injure another if an injury results from the misrepresentation or the removal. That is C. So what does that all mean? What it means is Hewitt tells us what it means. Hewitt involved protective rubber gloves and sleeves that were not supplied. The employer told the employees that they did not need them. Face masks for the dust that the employees were going to breathe in had been locked up and unavailable to the employees, and based on that fact pattern, an employee suffered an injury and filed an intentional tort case. And what Hewitt said is that protective rubber gloves and sleeves are not an equipment safety guard as set forth in subsection C of the statute, and that because they're not an equipment safety guard, that section doesn't apply to this case, and there's no basis for an intentional tort. And then Hewitt goes on to say that deliberate removal occurs when the employee makes a deliberate decision to lift, push aside, or take off, or otherwise eliminate a guard from the machine. So the court determined that that was not done in this case. And so even though you had PPE that was unavailable to the employee, and you had the masks, which were unavailable because they were locked up, the court held that these items were not equipment safety guards and that the employer did not deliberately remove them as the statute required, and therefore there was no presumption that any act was done with the intent to injure the employee. And the court also stated that the definitions of an equipment safety guard and the definition of deliberate removal are questions of law for the court and are not questions to be answered by a jury. So at first instance, a court has to determine whether the particular safety device or guard is in fact an equipment safety guard, and also whether the employer deliberately removed it, because that has been defined in the case law. And again, remember, if you do have an employer that deliberately removes an equipment safety guard, that creates a rebuttable presumption, which means at trial, it will be presumed that the employer committed an intentional tort and committed an act with the intent to injure. However, the employer can put on evidence to rebut that presumption and show that it did not deliberately intend to injure this plaintiff. So it's really a burden of proof mechanism, a procedural mechanism used to get to a final result in a trial, and who has the burden of going forward with the evidence. And then this Pixley Pro-Pac, relatively recent case that we were involved in, it makes it clear that the deliberate removal under C of 274501 is the careful and thorough decision to get rid of or eliminate an equipment safety guard. The mere fact that a guard doesn't work is not enough. And then, almost done here, a couple more slides. There are two lower court decisions, both Court of Appeals decisions. The first one's from the 7th District, and they are examples of appellate courts trying to expand the terms equipment safety guard and deliberate removal. In the Wineberry case, the court held that the deliberate removal of an equipment safety guard includes the failure by the employer to attach a piece of safety equipment that was provided by the manufacturer. And so if an employer buys a piece of equipment and it comes with a guard of some sort or some type of a safety device, and that is not placed onto the piece of equipment, at least the 7th District in this Wineberry case has held that the failure to put that piece of safety equipment on the machine as recommended by the manufacturer would amount to a deliberate removal. That holding sort of flies in the face of the prior Supreme Court holdings, and specifically Pixley. And then this Oberlanders, Thompson, tree service, they were dealing with a chainsaw. And I don't know anybody has operated a chainsaw, but there's a guard in front of the chainsaw that you push away and it'll lock the chain. And then when you're ready to cut, you pull in this bar towards you, and the chain then it gets engaged and cuts. And so whenever you're not cutting, you should always engage that guard to prevent the chain from moving. Well, in Thompson, what happened is that guard broke off. There was no guard there. And Thompson failed to repair it or to replace it. And sure enough, an employee cut himself in the leg and had a serious injury. And he files an intentional tort action. And the 3rd District Court, a couple of years back, holds that deliberate removal of an equipment safety guard includes the failure to either repair or replace the safety guard that's provided by the manufacturer or that's required by law or regulation. So that guard was required by law or regulation, and it was also required by the manufacturer. So by the employer not repairing or replacing the guard, it opened itself up to intentional tort liability. But again, I would remind you that this appellate court decision is contrary to some prior Supreme Court decisions. But the Supreme Court did not hear this case. They don't hear every appellate court decision. But I wanted to make sure that you knew that the plaintiff's bar is continually filing intentional tort actions, and they are focusing on the deliberate removal of equipment safety guards to expand the scope of intentional tort liability for employers in Ohio. And these two cases are perfect examples of what's going on. So you've got these two causes of action, intentional tort, VSSR. Pretty much they're separate and distinct. They're filed in different venues. You know, you've got the commission for VSSRs, you've got the court system for intentional tort. Damages are different. However, the similarities are they concern guarding or lack of guarding or lack of safety devices. And so when you do receive a VSSR, you have an injury that involves a piece of machine, and maybe there's an allegation that the machine wasn't guarded or that somebody bypassed the safety mechanism. My experience has been that not only are you going to be faced with a VSSR claim in that situation, but if in fact it's a serious enough injury, you may well be faced to defend an intentional tort action, especially if it deals with an equipment safety guard that was not functional or was not in place. I mean, these two cases give plaintiffs' attorneys a roadmap. It's going to be a difficult road, but there are a number of attorneys in Ohio that are going forward with these cases. They're usually being referred to them from the compensation lawyer who has handled the VSSR. So be on the lookout. There's not much similarity, but they sometimes are spawned by the same incident. So that's all I've got today.
Yeah.
Thank you very much. I appreciate it.